is an issue because, well, maybe to the extent of bulk, but with regard to what is actually being captured, which is the numbers dialed, are you saying that because the government is collecting that in bulk, in other words, for 7 years or whatever, of your client, that is unconstitutional?
That's right. I think if in 1979 the state of Maryland had investigated Michael Lee Smith not through the targeted use of a pen register, but because it had from the moment of his birth created a database of every phone call he ever made or received and kept that database in a government coffer, I think the Supreme Court would have understood that case to stand for a very different proposition, and I wager they would have found that collection unconstitutional. So if that were the program that we were challenging, I still think it would be unconstitutional. Although I'll note that's not, it's more intrusive here on a number, for a number of different reasons.
Well, how do we? I'm sorry.
No, go ahead.
How do we go about? We've been looking at this stuff and worrying about this. How do we go about knowing, without any fact-finding at all? I'm afraid I keep looking and wondering whether we're having in-camera proceedings here. But I'm wondering how, without any fact-finding at all, can we begin to figure out, by a district court, by some trial court, presumably in camera, how can we begin to know whether this is reasonable or not? I mean, how can I begin to know whether, we're really, because of the way the world is today, which is different from the way it was a week ago and different from the way it was a year ago when this started in June of 13, how can we, without fact-finding, come up with some reasonable determination of reasonableness?
I don't think fact-finding is necessary. The parties have briefed the issue, and even the president now concedes that the government can accomplish the interests it is seeking to serve through this program without bulk collection.
Well, if the president thought that, why did he send his lawyers here to say that you should lose?
I think he's awaiting a legislative solution. The president in the interim has, I suppose, decided to defend the program.
For the moment, evidently, the president thinks that it is necessary to continue operating this program and that it's constitutional to do so. He might prefer some other way of doing it, but the representatives of the government are here to say that they think this is presumably essential, but at least that it's a reasonable thing for the government to be doing.
Our view is not that the president has conceded the unconstitutionality of the statute, but that of the program, but that the government has conceded that there are alternative, significantly less intrusive means for the government to accomplish.
But nonetheless, fair enough. And one would hope that does surely sound like the rational way to proceed. And we started out with that question. But supposing, because of legislative blocks, as Judge Lynch spelled them out, the possibilities that politically it won't fly after the election, and we're stuck with what we've got. That is to say, the whole country is stuck with either we say this is unreasonable and or it's a violation of the Fourth Amendment, or we conclude it's reasonable under the circumstances, given both the nature of the threat and what has to be done to control that threat. I mean, how do we do that based on briefs?
So if I could, I'll make a few points.
Please. The
first point is to make the one that I tried to make earlier, which is that I don't actually think the court even needs to get to the reasonableness balance. The government is only entitled to a question of free-floating reasonableness if it can demonstrate that the warrant and probable cause requirements of the Fourth Amendment are impracticable. And it cannot, for the simple reason that there is record evidence, there is now a national consensus that the government can accomplish its interests through individualized applications. In other words,
that wouldn't ordinarily require either probable cause or a warrant. In other words, this alternative procedure that we're envisioning, that you're envisioning, that the president apparently is envisioning, is one where Verizon keeps these records. And I take it, if you had a reasonable suspicion, or even an unreasonable suspicion, but some reason the government wants to look at one person's phone records, They do that all the time by issuing a grand jury subpoena or perhaps some national security letter or something of the sort without probable cause and without a warrant. And the argument is that's not a Fourth Amendment. Either it's not a Fourth Amendment event because of Smith against Maryland, or if it is, it's a reasonable one.
That's right, but the government here is trying to engage in bulk collection. Right. And if we're correct that that implicates the Fourth Amendment, then the question becomes, for purposes of the special needs doctrine, which the government has invoked, the first question becomes whether the government could accomplish its interests through targeted demands. If it could, then it is not entitled to forego the requirements of the Constitution. Now, we don't think it could use targeted demands to engage in bulk collection, but right. Even the government has conceded that it could use targeted demands to accomplish its interests here. It uses a seed phone number to query its database. Instead of querying a database, it could use it to query.
Right, but I'm just questioning, isn't what you're just saying the so-called free-floating reasonableness inquiry? It's an inquiry into whether what they're doing now in terms of bulk collection is, in light of possible alternatives, perhaps, a reasonable thing to do or an unreasonable thing to do. I don't know why the warrant requirement or the probable cause requirement comes into play in that inquiry.
I suppose it's because, at least in this case, the question of practicability seems to collapse with the question of reasonableness. But I think they are distinct inquiries. Under the special needs doctrine, the first question is whether dispensing with the requirement of individualized suspicion is practicable or not. Here we don't think it is. Even if it were impracticable for the government to acquire these records in an individualized fashion, we would still think that the program is unreasonable, for the very simple reason that it is the most intrusive means that the government could use to accomplish its very narrow interests. That sort of program has always been held to be unreasonable. And it's in part, and I think this is a critical point, and I'll emphasize it again, it's in part because even the president has conceded that the government's interests can be accomplished in narrow means. And it's not just the president, it's the Privacy and Civil Liberties Oversight Board that wrote a very lengthy report concluding that bulk collection is unnecessary. It's a hand-selected review group, a group hand-selected by the president himself, that came to the same conclusion. And there's record evidence in this case from Professor Felton, who's a professor of computer science at Princeton, explaining very simply how the government could recreate this program in a targeted way that would not require bulk collection. I think that showing goes to both the question of practicability and reasonableness. If Your Honor disagrees, then I will defend our ground on reasonableness, but I still think it goes to the question of practicability.
I think we, unless my colleagues have further questions, I think once you get to the point of saying it's time to re-emphasize the point that you already made, we've probably gotten to the end. So I thank you for your argument. You do have some time for rebuttal, which will probably be